Hello everyone. Today we're going to see second writ. Yesterday we saw writ of certiorari. Today we're going to see writ of prohibition. At the cost of repetition, I'm just going to recommend this book. I rely upon this one. I refer this one. Writ Remedies by Justice Banerjee. It's a wonderful book. People who want to get well acquainted with writ matters, can buy and refer this book. So what this writ is all about? In fact, this is identical to the previous one which we saw, writ of certiorari, but for one different. What is that different? The earlier writ is invoked, becomes applicable, or can be invoked only when the matter has been settled after the fact. But this can be done when it is in the course, when it's going on. So that one, once it has been completed, certain conditions are satisfied, it can be invoked. This one, when the matter is ongoing, even while it's ongoing, these conditions which were applicable for that writ are satisfied, and those conditions are identical as well to the other writ of certiorari, are satisfied, then this can be invoked. So that one is done when it's after the fact, when an order has been issued, and the supervisory court, the constitution court, either high court or excuse me, supreme court, can call for that order and quash it if those conditions are satisfied, and the petitioner can convince the court successfully. This, while the matter is ongoing, while it is still pending, still those conditions such as exceeding the jurisdiction or lack of jurisdiction, or in utter flagrant disregard for fundamental right or principle of natural justice, or at the face of it, on the very palpably against the law, with the contravention to the rules laid down, this can be invoked when the matter is still pending, the matter is going on. This is the one and only difference between that writ of certiorari and writ of prohibition. So now, what are the condition? One thing I have to I'm sorry, I have bad throat. One thing that I have to stress upon here is that this writ jurisdiction do not act as an alternative to an appellant court. So something extraordinary have to be done, have to be committed, which is so wrong on the face of it, that should have happened, for which merits this interference, which calls for this interference by the constitution court. One, the basic is that when a lower tribunal or whatever the authority which is quasi judicial in nature, anything which is quasi judicial, any authority which is quasi judicial or judicial or quasi judicial, which acts without jurisdiction or exceeding jurisdiction, that's term called quorum non judici, which means that it has no jurisdiction to adjudicate upon that matter, or which has jurisdiction but while adjudicating upon it exceeds its jurisdiction. In this case, this writ can be invoked. Number two, on the face of it, it acts against like a principle of natural justice or contravention, blatant, flagrant, and conspicuous disregard to the rules which ought to be followed. Only on these two conditions, this writ can be invoked. And I will give you by an example which I pulled it out of my mind, not from any book. So take it with a pinch of salt. Let's say that there is an authority created to keep a check on predatory pricing. So that if some, let's say that three businessmen sell a product, and one businessman has a lot of cash chest, enormous amount of cash, so he decides to lower the price very much, so that he can run the other business out, run the other people out of business. Till he runs the other people out of the business, he will lower it to a bare minimum price, and once he has run them out of business, then he can quote the price as as much as he wants. He is complete in a dominating position. So an authority is brought in to keep a check on this matter. And but this is example which I pulled out of my mind. So that authority, while can decide whether such price is predatory price or not, but it exceeds the jurisdiction by deciding whether a particular person can involve in this business or not, can operate in this business or not. That's not like a power that has been conferred upon that authority. So the moment it start determining that question whether Mr. A should involve in this business or not, that's where it transgresses jurisdiction, exceeds its jurisdiction. It goes out of the limit that which has been drawn for it, which has been the power that has been accorded on it. So the moment it passes the jurisdiction, it crosses the jurisdiction, this writ becomes applicable. And in a lot of matter like tax assessment and other matters, where the petitioner feels that they're acting in excess of the jurisdiction or utter disregard for the law or principle of natural justice, then in in those cases too, this writ can be invoked. This is almost identical to the writ of certiorari, except the one which is that is invoked after the fact. This is invoked when the matter is still going on. The other thing is that this is a negative remedy. Both are negative remedies. Unlike mandamus, negative remedy means it can only undo the wrong. It cannot say what should be done as a course correction. Unlike mandamus, which says that this should be done. This both writs, these both writs cannot say that undo this, undo this. It can only undo this, undo what, undo the wrong that has been done, or undo the wrong that is going on, that's going to be committed. And thank you so much.